are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1016 et al. Environmental Defense Fund petitioner versus Federal Energy Regulatory Commission. Ms. Karras for the petitioner Environmental Defense Fund, Mr. Robertson for the petitioner Julie Steck, Mr. Viswanathan for the respondent Ferc, Mr. Franklin for the intervener.
Good morning, Ms. Karras.
Good morning.
Can proceed. You can proceed.
Thank you, Judge Tatel. Good morning, and may it please the court. Natalie Karras for Petitioner Environmental Defense Fund. I'd like to request 2 minutes for rebuttal. Under the Natural Gas Act, FERC can only approve a proposed pipeline if it is required by the public convenience and necessity. This demanding standard must be satisfied before private companies such as Spire can use eminent domain power to take homeowners' property and permanently alter the natural landscape. In the orders below, FERC relied exclusively on a single affiliate precedent contract agreed to behind closed doors and paid for by captive customers in a region with excess pipeline capacity and no new load growth. FERC's orders are deficient for many reasons, but I highlight the two most egregious errors today. First, FERC relied exclusively on an affiliate precedent agreement signed by a utility with captive customers to demonstrate market need, despite significant warning signs that the affiliate arrangement compromised the probative value of that agreement. Second, FERC violated its own certificate policy statement by performing a deficient balancing analysis, which ignored the affiliate project's adverse effects on landowners, the environment, and existing pipelines and their customers, and relied on vague and illusory benefits. As to the first point, in her dissenting opinion, Commissioner LaFleur stated that the Spire affiliate project is the unusual case of a pipeline application that squarely fails the threshold economic test. FERC relied solely on the utility affiliate agreement to find need, ignoring record evidence that significantly undermined the probative value of that agreement.
What do you think the most significant evidence is that undermines that?
The most significant evidence, it's a series of factors that illuminate the skewed incentives underpinning the agreement and the market conditions in the area. So Spire is a single dominant buyer within the region and can simply pass the costs on to captive customers. The region—
yeah, but under City of Oberlin, they can rely on a precedent agreement, even with an affiliate, absent evidence of self-dealing or, right? So that's why I ask you, do you agree with that about the City of Oberlin, if that's what that says?
Yes, I agree in that case that the court referenced the self-dealing. The facts in that case are completely different. In City of Oberlin, there was increased demand, and the project, the Nexus pipeline, was supported by a diversity of subscribers. And
yeah, so the question before us is whether FERC's decision was arbitrary and capricious in the extent to which it examined the evidence of potential self-dealing, correct?
Yes, FERC had to look at the self-dealing issue. That is correct.
So that's why I asked you, what's the strongest evidence from your perspective that FERC should have looked at and didn't?
The strongest evidence is the comparison of the cost of the transportation capacity that Spire paid Spire, which is 25 cents per decatherms, and that is at Spire's brief, page 21, note 4, that exceeded the rate for transportation capacity on the neighboring pipeline where Spire turned back the capacity. And the cost of that capacity ranged from 10 cents to 22 cents per decatherm, and that was in the joint appendix at page 842. That alone—
Wait, I'm confused. I thought FERC said there was no material difference in the two rates. Is that wrong?
So FERC in the paragraph talking about the delivered cost of gas, the delivered cost of gas incorporates both the commodity, the molecules of gas, coupled with the transportation capacity. If you look at the cost of the transportation capacity alone, it was higher. And even if you looked at the delivered cost of capacity, FERC found there was no material difference between the Spire pipeline and the neighboring pipeline. And coupled with that, there were significant market conditions. The region has a track record of failed projects. There is already available excess capacity in the region. No other entities bid on the capacity. The project provides no meaningful cost savings for customers. Spire turned back the cheaper transportation capacity on the neighboring pipeline. The state regulator warned that the region could not support an additional 400,000 decatherm per day project. The precedent agreement was the result of internal discussions among Spire, not an open season. There was no transparent or competitive process to compare the affiliate project with non-affiliated alternatives. Numerous parties protested the project, including the neighboring pipeline and the state commission, and the neighboring pipeline considered joining the project as a co-developer, but ended the discussions when it concluded that the project was uneconomic on a standalone basis. As put by
Counsel, you say that FERC relied solely on the precedent agreement, and I'm not sure I'm completely understanding that. Didn't they cite other reasons to justify their decision? Enhanced reliability and supply security, reduce reliance on older natural gas pipelines, et cetera. There were several reasons given, not just the precedent agreement, right?
So under the FERC certificate policy statement, the threshold economic question is whether there is market need for the pipeline. And to make that finding of market need, FERC relied exclusively on the precedent agreement. Parties asked FERC to consider additional evidence on the issue of need, and FERC said, no, we disagree, we need not do that. That was at paragraph 75, Joint Appendix 963.
I know, but what I'm trying to figure out is, what weight do I give to these other factors that FERC is reciting to justify its approval? The test is confusing as being applied. You're arguing past each other or maybe past me. On the one hand, there is heavy reliance on the precedent agreement, but on the other hand, FERC does recite other factors. So on the one hand, they're disclaiming a need to go behind it. I don't know what that means because they recite other factors that they think supports their approval.
So the first threshold question is there a market need? If you can answer that question in the affirmative, then you consider whether the project's public benefits outweigh adverse effects. And FERC considered those other factors.
Now, do you think the absence of market needed or a flat market kills the project? That precludes FERC giving approval? That's not my understanding.
So there could be an example of a project that is needed for reliability. There's no record evidence here to suggest that reliability would be compromised if the project was not built. Just like if you build.
Well, but they're saying reliability will enhance with the project being built.
Right. So just as if you built 10 additional pipelines to St. Louis, all of those pipelines would enhance reliability. So FERC must first look to see whether there's a market need. FERC found if the project is not built, the Spire, Missouri will rely on existing systems in the area.
No, I understand that, but what I'm trying to understand is the absence of need killing. I mean, does that end the inquiry? If there's if they show flat demand and no likelihood of increased demand, then FERC should lose in all such cases?
No, there could be a situation where there is no new load growth and a project is proposed for the specific reason, to enhance reliability. That's not what the project was proposed here for. It was proposed, FERC found that.
I thought your point was that, I thought your whole point here was not that the absence of market need would kill the project, but that it simply requires FERC to look more deeply into whether or not there is self-healing, right? Isn't that right?
So yes, did I
miss the point of your whole brief?
No.
You're not asking, you're asking for a remand to FERC to examine the evidence of potential self-healing, correct?
Yeah, you're going to have to answer that because I'm now confused as to what point you're relying on. Because it sounds like I'm not interrupting, David. I want to make sure she
Oh,
answers.
that's okay. Go ahead, Harry.
Answered, but it sounds like your principal argument is they relied solely on a precedent agreement in a flat market and with a deal with an affiliate. And that should end it. I heard you saying. Now, Judge Tatel is asking a slightly different question, whether FERC failed to address self-dealing, and which is it that you're relying on, or how do you relying on, or how are you weighing them?
So I would say it's the threshold question is whether there is a market need for the pipeline. And what FERC did in this case, it looked exclusively at the existence of a precedent agreement. It didn't look beyond the fact and consider.
Well, that's why I keep asking you, do you think that that ends the inquiry? Because there is no need here. At least as I understand the record, they can't show a need. It's a flat market. Unless you define need as increased reliability and such factors, there isn't an increased demand here. And I'm trying to understand from you, are you saying that's the end of it? If they cannot show an increase in demand to show that kind of a need, that should be the end of the inquiry. Is that what you're saying?
Yes, it should be the end of the
Now, what case says that?
Well, so I would say that, well,
the only time you can build a pipeline is if you can show there's going to be increased demand, and you've got to meet that increased demand. That's what I hear your argument to be?
Let me just take a step back. So I'm not suggesting that there could never be a project where there is flat demand and a project is not demonstrated to meet a need, for example, of reliability or flexibility. Like that is an example that could occur. FERC could go down that path. That is not what FERC did here. It relied exclusively on the existence of the precedent agreement.
By saying that, do you mean if there were actual reliability concerns, like the existing pipeline kept breaking, kept shutting down, or was a very unreliable source, so there was a real problem, then that could certainly demonstrate need, even if there weren't, just to keep getting in what you're already getting has proven to be a problem, even if there isn't an increased demand for gas. But in this case, the reliability and flexibility, they could have already done something. It was kind of icing on the cake. It was just more reliable and more flexibility, which any new pipeline can add. Is that your point?
Yes, thank you. That is my point. Thank you.
And then on
your,
go ahead, Dave.
Sorry. No, you go ahead, Patty. I'm going to change the subject slightly.
Oh, I'm so I think we're all having trouble analyzing this. The role of economic need here. I thought it was a sort of both point, and that is first, in the absence, if they, FERC having said the only basis for economic need is agreement, then it rises or falls on that at that first step. And then at the second step, even if we go past that first step, when we get to the balancing, the lack of need also weighs in quite heavily in the balancing test and requires a much higher showing of public benefit to make up for the absence of need. Am I wrong about that?
That's correct. The two prongs are related in the fact that if there are significant adverse effects, as there were here, that requires a heightened demonstration of need.
But as to the questions that you were being asked about the role of economic need, just as an independent test by itself, I thought that ordinarily we only look at economic need as a freestanding inquiry when you're talking about an existing pipeline, which we aren't doing here. And so really, under FERC's certificate policy statement, this should all be a question under the balancing test.
So you are correct that if this was an existing pipeline, FERC would look to see whether other customers would be subsidizing the project. But because Spire is a new entrant pipeline, that question was not implicated here. So FERC has to, under that first question, look at whether there is a market need. And here it looked exclusively at the precedent agreement.
And what role would affiliate abuse play? Would that just negate a showing of need, or does that come into the balancing test? Or if we find affiliate abuse, and this is the only agreement they're relying on, that, does that end the inquiry? So it's not just no market need, it's flat need, but there also was affiliate abuse. Would that end the inquiry, or would that go into the balancing test?
So I would look at Commissioner LaFleur's dissenting opinion, where she left affiliate abuse out of the analysis altogether. And she simply said,
I know, but I'm asking you if there are concerns about, because Judge Tatel was asking about concerns about at least the sufficiency of analysis of whether there's affiliate abuse. And I'm trying to figure out where that fits into these different stages of the test we've been talking about.
the affiliate abuse undermines the probative value of the agreement.
Mm-hmm.
And so to exclusively rely on the existence of an agreement without analyzing the significant warning signs that compromise the probative value occurs in that first step of the analysis.
And I'm sorry, Judge Tatel, if I could just ask one more question.
Yeah.
Are you aware of any Ferc cases? Oh, sorry?
No, go ahead.
Okay. Are you aware of any cases from this court or Ferc defining what affiliate abuse means? And if not, do you have a definition?
So I would look to the Cove Point decision, 68 Ferc 61128. And in that case, it involved a regulated affiliate purchasing storage services from the pipeline applicant. So just as Spire, Missouri is a gas utility, you had regulated gas utilities seeking to purchase storage services at market-based rates. And FERC expressed concern in that case that a regulated affiliate purchaser could purchase servicers above those established in a competitive market. And so it denied the rate proposal in that request and found that there was a significant concern regarding the threat of affiliate abuse. There's a whole host of other cases falling under different statutes that FERC administers, where it finds the threat of affiliate abuse and takes action and steps in to address it.
So it doesn't actually have to find affiliate abuse. It's really, if it's sort of an eyebrow raising test, if it seems concerning, then that takes material error out of a claim of need, as in this case.
Right. It was the threat of affiliate abuse in the Cove Point case that FERC sought to address.
So they didn't actually go forward and say, you had to actually find it and prove it. It just there was kind of a smell test.
Right. It was the economic incentives and the fact that the utilities, the affiliates could work in concert together to increase prices to captive customers.
Sorry,
let me try again to make sure I understand. I apologize if I'm not getting your point. Again, because I hear you starting out by saying they relied solely on the precedent agreement, period. I can understand the argument in the abstract, but I'm not sure that's what the record is suggesting. They thought a justification for the pipeline was to enhance reliability and supply security, reduce reliance on older natural gas pipelines, reduce reliance upon mature natural gas basins, and eliminate reliance on propane peak shaving infrastructure. Did FERC credit those things?
So in the initial order, FERC declined to credit those. It found that those issues fall within the scope of a business decision of a shipper, and it would not look at it. In the rehearing order, in paragraph 24, which Commissioner Glick described as a throwaway paragraph, FERC described those issues as benefits.
All right, so that's my point. That you characterize them a certain way, to me, is beside the point. In the rehearing order, when pushed, they're resting on it. Now, are you saying their reliance on those interests are bogus? And if so, how so? And if it's not bogus, why isn't their reliance on those interests sufficient to overcome your claim that all they did was rely on the precedent agreement? That's what I'm trying to understand here, because they did cite these things. Now, here, what I'm hearing from you, you're saying, yeah, Judge, they did in the rehearing, but that's nonsense. And I'm saying, really, why is it nonsense if the words are written?
So there was significant record evidence undercutting each of those justifications. So multiple.
So it's arbitrary and capricious because what they claim to be relying on is not supported by the record. That's your argument? See, I didn't get that. I would understand that's typical arbitrary and capricious review. You're saying they claimed in the end analysis to be relying on these four things that the other side is relying on, but really the record does not support that. I didn't read you to me making that argument. Is that what your argument is?
So I'm saying we can end the inquiry after the first prong, the threshold economic test. We could end the inquiry. It falls on that prong. But
well, and I asked you, where is there a case that says if you don't have demand, that's the end of the inquiry? And you said you don't have one. You don't have any such case.
Well, it has.
That's why I don't understand. You're saying, you're looking at the precedent agreement and you're saying, but there's no demand and this is with an affiliate and so that should end it. And I'm saying, that's fine. If you're right, where's their precedent for that proposition?
There has never been a case before FERC with this exact set of facts. There has never been a single utility affiliate
Okay, so do it this way for me. I know there isn't any such case. So now you be the writing judge. You're now asking us to make up something that has never been done before. And what would our justification be? What would we say? You're saying if the precedent agreement is all they have in a flat market, that's enough to overturn it. There's no precedent to support that. How would I write that?
So I would look to this court's decisions in three cases: the Tejas decision and the Missouri Public Service Commission and the Leclerc decision. And those three cases all stand, define FERC's Section 7 obligation. They all say the court has found that FERC cannot fulfill its Section 7 obligation by merely relying on the existence of agreements entered into by retail gas utilities, because the utility can simply pass those costs on to captive customers. FERC retains the responsibility of making an independent judgment and has the duty to use its Section 7 power to protect the public interest. Those cases.
Okay, you know what? Let me immediately tell you what I'm thinking as you're saying this. I'm thinking they have, in the rehearing, relied on the interest cited by the other side. And you simply respond to me saying, well, that's a blow off. Why? As a judge, how can I just say, well, that's nonsense, unless you show me that what they've relied on that has been cited by the other side is not supported by the record. And I didn't hear you to make that argument in the brief.
So may I address that now?
Yes, please. I'm sorry to press you, but I'm really trying to understand the theory.
So there was significant record evidence undercutting all of those justifications.
And did you argue that in the brief, that it's arbitrary and capricious because the record doesn't support those claims? I missed it if you did.
Yes, in our reply brief, we talked, there are three overlapping obligations here. There's the obligations under the Natural Gas Act, there's the obligations under the Certificate Policy Statement, and then there's the obligations under the Administrative Procedures Act. And FERC's orders here violate all three of those overlapping legal obligations.
Okay.
I thought, Ms. Karras, I'm completely confused.
I'm done, David.
Well, I just want to follow up on your.
Yeah, no, that's fine.
Because I think you focused in on this. I had understood your position to be that at the first stage of this, that is the market analysis, that the failure here was that FERC did not adequately consider evidence of self-dealing, right? And that we don't even get to the balance. Isn't that your theory? And with respect to the four items that, well, let me ask you that. Am I right about that?
Yes, the point that we're making here is that the precedent agreement was not enough, and that the threat of affiliate abuse undermined the probative value of that agreement. So the issues are intertwined.
Under our case law, a precedent agreement with an affiliate is perfectly okay, absent evidence of self-dealing, correct?
There has never been a case with this set of facts where the project is supported exclusively by a utilities captive customers. That has never been presented before this court. And so, as Commissioner Glick said in his dissenting.
In the city of Oberlin, we said a precedent agreement with an affiliate is okay by itself, unless there's evidence of self-dealing, right? That's why I asked you the very first question I did. I thought the question in this case was whether or not Ferc had acted arbitrarily and capriciously in not considering the evidence of self-dealing that you think exists in the record. And with respect to the four factors that Judge Edwards mentioned, I thought your position was, yeah, commission cited them, but didn't actually review them, didn't actually consider them. Am I wrong about that?
Right. It was one paragraph. It was what Commissioner Glick described as a throwaway paragraph.
Yeah, well, he describes it that way, but you know, we do a lot of stuff in one paragraph sometimes.
Right. That's not helpful.
Pack a lot into a paragraph. Sometimes even a sentence.
So I can walk, if I may, I can walk.
Just tell us, go back to Judge Edwards' question. What do we do about paragraph 24?
Yes, so there is significant record evidence that undermined all of those justifications. So first, there was multiple pipelines that already provide Spire, Missouri access to supplies flowing from the Rex pipeline. And Spire, Missouri already has a transportation path that avoids its seismic zone. That's in
Is this all in your opening brief where you're attacking that paragraph?
In our opening brief, we attacked the
No, really, stay with me. And I don't mean to be a pain, but I really need to understand. I hear what Judge Tatel just asked you. It's what I've been trying to ask you. Did you, in your opening brief, focus on those factors and say there's no record evidence to support those findings? Because I don't remember it.
So we presented record evidence to undermine the claim that regarding the need for the propane facilities that was included in the opening brief. And there is significant additional record evidence to undercut all of those other justifications. If I could walk through that now.
Before you do that, can I just say, like, your second D2 of your opening brief on page 39 is the record does not support Ferc's finding of benefits?
That's what I'm trying to find out.
So you did argue it in your opening brief. That seems to me the short answer to Judge Edwards. You did argue that in your opening brief, that the benefits were not supported by the record.
And you went through that paragraph and those four factors.
So we made the precise point that Judge Millett.
No, I hear what Judge Millett, and I read the heading. I'm asking you, did you go through that paragraph and cite those four factors? I mean, it's a really straightforward APA type argument that we get all the time. Either did or you didn't. An agency relies on four things. They clearly they're relying on four things. They're doing it in the rehearing, but they rely on it. And all I wanted to know is, do you think in your opening brief, you took that apart and said, 1, 2, 3, 4, they're wrong. There's no record evidence to support it. You either did or you didn't.
Yes, I think we did make that argument in section D2 of our brief. We explained that the balancing analysis was completely deficient here.
And you said because it's a perfunctory assertion of benefits, and it was just conclusory with no backing it up by Ferc. Ferc didn't back it up. It just made those statements. It didn't make any findings. I checked that. That's what you mean by perfunctory. And I think you cite the dissent saying a conclusory sentence stating that there's these benefits, right?
Yes.
So that's arguing there was no, I mean, you can be right or wrong about this, but that seems to be an argument that there was no there when Ferc invoked those other concerns. Obviously, the other side may well disagree with that characterization, but that seemed to be your argument to me.
Yes, that is what we were seeking to do in our brief.
Let's go on. If it's okay with my two colleagues, let's go on and hear from the other petitioner. And
Yep.
Ms. Cass, will give you a couple minutes on rebuttal. Okay.
Thank you.
Mr. Robertson.
May it please the court. My name is Henry Robertson on behalf of Julie Steck. Late last week, the court ordered that the parties be prepared to address Ms. Steck's standing. We did address it in our opening brief and in the declaration of standing that was filed as an addendum to that brief. And I laid out the case for injury to aesthetic, recreational, and safety interests, which are ongoing, and also independently procedural standing for procedural injury that may be redressed on remand and reconsideration of the environmental issues.
On your first point, aesthetic injury, she says, your client says that she's injured because she drives by this ugly station 3 times a week, right? Do you have a case that supports that for Article 3 injuries?
There is case law on, she said that it is not in keeping with the character of the neighborhood, which is residential and wooded.
But she drives, I'm asking about, she drives past it. She doesn't live next to it. She drives
She lives 1/2 mile down the road, and in order to
Am I
go,
wrong that she says the injury comes from driving past it 3 times a week?
yes, that is the only route by which she can reach the north-south artery in that area, Riverview Drive.
What's your best case for that being part?
I don't think I can single out a case at this time. But it's enjoyment of her property, the character of the neighborhood. There's also her recreational interests in the park, and the safety concern regarding the sharp S curve around the meter and regulator station.
So did the construction of this facility create that sharp curve?
Yes, it did. Made it a blind curve at any rate.
The road didn't curve before the construction of the station?
If it did, it was not a blind curve. You cannot see around the thing that sits there now.
Does she allege that in her complaint, in her affidavit?
I believe so, yes. We certainly allege that it was a safety hazard.
No.
It's a blind curve. We did allege it was a blind curve.
By the construction?
Caused by the construction of the meter and regulator station.
What was there before the meter on that land?
I believe it was woods. They cut a number of trees before they built it.
You said there were a lot of trees there. That was sort of the character of the region. Did the trees obstruct the view around the S-curve?
I don't know.
We don't know that. So we don't know if when I get that there's now a building where there were trees and you have a dangerous S-curve, the question is whether you could see any better around the S-curve from trees rather than a building.
I would have to ask her. It requires.
Well, no, that's not the right answer. The answer has to be in her declaration. And I know I'm about to go beyond the record a little bit, but my law clerk looked on Google View, what do you call that thing? Mm-hmm. Google Street View, and he says you couldn't see around that corner even before this thing was built because of the trees. Now, that's not record evidence, but that's why the declaration has to have something in it about causation. I mean, the declaration has to state that the construction of this actually caused it. In other words, that this was not a traffic obstacle prior to the construction of the facility. That's what causation is all about.
Well, I could consult her and ask to file.
That doesn't help you. You rise and fall on your declaration. Here, that's it. And maybe it's enough, maybe it's not enough, but we don't have cases where you say, okay, well, it's not enough at oral argument, so you go talk to the client. This is the record on which we have to decide Article 3 standing.
Well, there is precedent for supplementing.
Okay, but so you're agreeing then that it's not in the declaration, right?
No, I don't think it says enough in the declaration about the previous character of that intersection.
That's fine. Thank you.
But we still have procedural standing.
Can I ask, first of all, I just have a fact question, and that is, I'm a little confused. The Chain of Rocks station existed before the construction, and is that right? And it was just expanded to this corner in the construction? Is that what happened?
No, I believe it was brand new.
It was brand new? Okay, because some of the record evidence indicates that they were connecting to an existing station, but then there was some supplemental construction. But you think the whole thing?
Yeah. If there was anything there before, it was much smaller. There was a big embankment added on the east side, the river side, and fencing all around, and at least two large buildings. There are pictures in the
okay. And then I'm sorry, go ahead.
I'm done.
And then you mentioned a recreational interest. Can you?
That
remind-
relates to the park under which the pipeline was run, where she kayaks and hikes.
Does that prevent her from kayaking or hiking? The pipeline's underground there,
Yes, it is.
so she can still hike and kayak without seeing anything.
Yes, you can.
So what's the injury to her recreational interest?
Was during construction. I can't say that it's ongoing.
Oh, so that was one, okay, I get during the construction time. Okay, thank you.
Okay. Did you have anything else? Because I think you're out of time.
Yes, well, I just want to say we have independently procedural injury from the NEPA violation. And that can be remedied on remand to the Ferc for reconsideration of the environmental issues. And that is not affected by the completion of the pipeline of the meter regulator station, but is an independent source of standing.
And can I ask you one thing about your NEPA claim? And that is,
Yes,
so
please.
the point of this pipeline was to move gas from the Marcella and Utica shales processes there, or mining activities. And my understanding is those are done by fracking.
Yes.
What was the method by which gas was extracted from when they were getting gas through the Enable pipeline? Was that also?
That gas came from down south, and I don't think it's in the record. I have assumed that it was conventional gas production, but I really can't say for sure.
Okay, all right. So I wanted to clarify whether your upstream effects argument involved a switch from natural drilling to increase in greenhouse gases associated from the switch from natural gas drilling to fracking, but it sounds like that wasn't your argument.
Well, that is my understanding. It is my argument that fracking as a technology has more greenhouse gas effect because it releases methane, fugitive
Right, but
methane.
you'd have to know where they were getting their gas, whether the gas before came from fracking, to be able to argue that that was a cause of upstream effects. And it sounds like it's not clear on the record whether that argument is relevant here.
I'm not absolutely sure. No.
All right, it's my mistake. Okay, thank you.
Thank you, Mr. Robertson. We'll hear from Ferc.
Good morning, Your Honors. Anand Viswanathan on behalf of the Commission. So there's a number of issues to get to, but before I do, I want to clarify one record point from Judge Millett's question about whether the chain of rocks metering station existed before. You can look at the beginning of the certificate order. This is JA 934, paragraph 6 and 7. Paragraph 6 says that there would be, as a result of the project, a reconfiguration of an existing chain of rocks interconnection with Spire, Missouri. And it describes how this is actually, it's essentially expanding an existing metering station. So it's not a brand new structure.
So there was already a metering station there, presumably with pipelines underground running to that metering station.
Correct. And I think that this issue about the safety hazard and the blind curves, I will say that there's nothing in the affidavit that makes clear when that traffic condition arose, like whether it arose as a result of the project under review or whether it pre-existed the project. I couldn't tell that from the affidavit.
Thank you.
So there are a number of questions of Ms. Karras on really two categories of issues. One was evidence of abuse when it comes to affiliate agreements. And the second one was, I think, whether or not the commission actually relied solely on the affiliate agreement here. And I think there was some focus on paragraph 24. Maybe I'll start there. And I think here it's worth clarifying there's a difference between the evidence that is offered or the evidence that the commission relies upon for a showing of need for a project, as well as versus the agency's independent obligation to address opposing views. And so with respect to this issue, I don't think you can separate those two. So what the pipeline offered was it offered the affiliate agreement, but then, as you all recognize, it offered a number of other rationales as well. And so what the commission said in paragraph 24.
Are you talking about the rehearing
You're
decision?
talking about rehearing?
Yes, my apologies. Yes, the rehearing order, paragraph
24. Before you get to 24, do you agree that at least in the original order, those factors did not factor into Ferc's analysis?
Yeah, there's no discussion of them in the original agreement.
They mentioned them at the beginning, but they never analyzed them. FERC never analyzed them. They never say that those factors are critical or a significant factor in its decision, right? It isn't until the rehearing order that FERC in paragraph 24 seems to actually engage. Do you agree with that?
I think I agree with that somewhat, Judge Tatel. I think the commission certainly looked more closely at these issues.
What does somewhat mean?
So what the commission said in the certificate order, it did recite those rationales offered by the pipeline applicant.
Right, but then it went on and said, look, that's up to them. Those are business judgment questions.
Right.
And I think that what the commission said was that based on the record before it.
That's not what it said. That's not what it said.
Well, okay. I think it said that in the rehearing order.
Right, so we agree it rises or falls in the rehearing order, right?
On those issues, yes, I think I agree with that.
All right,
and so,
go ahead and tell us about
okay.
24.
So what the commission said was that the Spire Pipeline offered a number of rationales in support of the project, and the opposing views were that the pipeline was not needed, and as a result, there would be an overbuilding of or excess pipeline infrastructure if the project were to be approved. And so what the commission said in that paragraph 24 of the rehearing order, JA 1155, it said that it found the rationales offered by Spire sufficient to overcome concerns of overbuilding. And based on that record, it found no reason to second guess the business judgments of the pipeline. And so I think based on that record, I don't think it's fair to say that the commission relied exclusively on the affiliate agreement here.
Well, if they're saying nothing more than there's no reason to second guess what has been offered, that's really not an agency doing its own independent analysis of the factors that would justify this proposal if they have to go further than the precedent agreement. And it looks like a case where there's no demand. All you have is a precedent agreement with one related affiliate, and the suggestion has been, and the possibility of self-dealing, and the suggestion is being made in that circumstance, FERC's got to do more. So it's not enough in the rehearing to just say at least I'm questioning you on it, to just say in passing, well, they propounded these and we have no reason to second guess. That's not agency analysis.
Well, I think two separate issues there, Judge Edwards. I think number one, what the agency can rely on, and then number two, I think you also referenced the issue of self-dealing. With respect to what the agency can rely on, I mean, the certificate policy statement makes clear that number one, servicing existing demand is just as valid a reason to approve a project as servicing new demand. Yeah. And that policy statement also makes clear that the commission will always treat a precedent agreement as substantial evidence of demand.
Sorry to interrupt, but what about a case like this where you have a pipeline that's not serving new demand, and B, providing no better price for the gas? And it's those two factors together that the petitioners say raises suspicions of self-dealing, and that's what the dissent's all about.
So I'm not sure that
before you get to let me just ask you this: you want to talk about paragraph 20? If we're just looking at the decision, the original decision, and all we have is a precedent agreement with an affiliate, and FERC agrees, because FERC agrees that the pipeline doesn't serve new need, doesn't serve new demand, and there are no materially significant cost savings. FERC agrees with both of those. So if that's the only record before us, what more evidence do you need to put an obligation on FERC to look carefully at whether there's self-dealing?
Well, I think that the way that the commission has treated contracts with affiliates consistently is that it treats them the same as contracts with non-affiliates unless there is evidence.
You're missing my question. It does treat them the same. I agree with that. A precedent agreement with an affiliate is fine. But in a circumstance like this one, where it's not serving new need and there's no price benefit for customers, Petitioner's argument, and I think this is consistent with the City of Oberlin, is that puts a burden on FERC to look to see whether there's self-dealing. And FERC didn't do that in the original order. Right? I mean, am I misstating what the law is?
Well, I don't know that the commission has said the burden is on FERC to look for self-dealing. I think the question is whether anyone has offered any evidence of self-dealing at all.
The point is, what more do you need than a pipeline, constructing a pipeline for an affiliate where it's not serving new market and providing no price benefit to the customer? I mean, that just leaves the obvious red flag that this is for the benefit of the shareholders, not the customers. Why else would they build?
So that is not how the commission has treated the issue of affiliate contracts. I mean, even with respect to City of Oberlin, we have the same record in the sense that there the court upheld the commission's reliance on the affiliate agreement because there's no evidence of discrimination, and number two, the pipeline bore the risk of unsubscribed capacity.
Wait, that's not, I'm sorry, Judge Tatel. There was no argument of affiliate abuse in Oberlin, and our opinion said so.
Right.
The affiliate agreements were only half of the agreements. You had non-affiliate agreements as well, and you had evidence of need. So it seems to me that what we said there and what happened there bears no resemblance to what's happening here for exactly the reasons Judge Tatel said. So let's just be careful about what we're saying about what we said was permissible with respect to affiliate agreements in City of Oberlin. So taking that understanding of City of Oberlin, I'm interested in your answer to Judge Tatel's question as well.
So, and I think the question was what more would need to be shown with respect to abuse or self-dealing?
To have a threat of abuse or self-dealing.
To require FERC to say something. That's what Judge Tatel's asking.
If it isn't this, what is it? What do you want? If it isn't these two factors that FERC concedes exist, what else could there be that would be more dramatic than this?
Remember, because your answer.
I just don't understand I don't understand your brief or FERC's argument that this somehow does not raise a flag, a red flag. I don't get that.
Yeah, because remember, you started out by saying when you look at that response in the rehearing, that FERC was fine because there was no reason for them to go behind anything. And we're like, really? And Judge Tatel is asking you very pointedly, in this situation where there are no new needs and there are no cost savings, is it enough for us to accept your argument that in this situation, they offered what they claimed were business reasons and we had no reason to go behind it? That's a strange argument.
Sorry, before you answer, Ann, is Judge Tatel on? I've lost his picture.
Judge Tatel is on.
You know what I look like. I'm still here.
Okay, I just want to make sure you're on for the answer.
Yeah.
Okay.
Well, so I think there is, again, a difference between what the commission relied upon here versus the issue of self-dealing. I think on self-dealing, the commission pointed out that no evidence at all had been offered to question the affiliate contracts, and the commission's approach.
I hate to keep interrupting you, but that's not the petitioner's argument. Petitioner's argument is that FERC ignored their evidence of potential self-dealing. FERC can't respond to that. You can't respond to that by saying, well, FERC said they didn't offer any evidence of self-dealing. They did. Their evidence is no market need and flat pricing. And then what all three of us are trying to get at here is why isn't that sufficient to at least raise a red flag about the possibility of self-dealing with an affiliate? That's the question we need an answer to.
Because one reason it is not.
Because if you don't have an answer to that question, then the case rises and falls on what the commission said in the rehearing order.
Well, at least with respect to the issue of abuse, I mean, one issue here is that what the petitioner has cited are cases involving a different set of issues. So there have not been any cases that they have cited involving approval of certificates of public convenience and necessity. All those other cases they've cited have involved the commission's review of rates, for example. So if a party is seeking approval of whether a rate is just and reasonable, then the commission might look more closely at whether there's an affiliate relationship there. But I guess our point is that they're not, that's not a comparison of like things.
Why is that not, as to the risk of affiliate manipulation? Why is it different whether they're doing it for rates or doing it for, to come up with some evidence of need?
Well, because here the commission's not reviewing a rate directly. It's reviewing whether—
I understand this isn't a rate case directly. I'm asking you why, when it comes to raising eyebrows or setting off the radar, at least the obligation to inquire further, why is it different whether it's a rate case, they're using the affiliate to justify as part of charging a rate, or you're talking about using them to establish need? Why is that different?
Because I guess for one, what the commission is doing here is it's not being asked to review an agreement. It's being asked to approve an application for a certificate. So that is different than the commission.
I get that procedurally what they're doing here is different. I'm asking you not for differences to what Ferc is doing. How is it different as to the concerns about the relationship between Spire and its affiliate, Spire, Missouri?
And part of this gets to a slightly different issue, but I think it's worth going there now, which is the commission pointed out that it's not the commission's role. And actually the state regulator also asked the commission to clarify that it is not the commission's role.
Okay, that's changing whose the role is. Okay, so your point is that this could be just as bad, but at this stage, this procedural stage, it's not Ferc's job to look.
At this stage, the commission's role is to rely on, if an agreement is offered in support of a certificate to show need, the commission is looking at the existence of the agreement. It's not reviewing the terms. That's, in this case, that's up to the state regulator.
You just said that the reason they're different is because this is the Missouri Commission's, Public Service Commission's wheelhouse, not Ferc's, to look into abuse. Is that right?
No,
that's what I thought you said. I misunderstood you then.
Well, I think what I'm trying to say is that it's up to the state regulator to decide whether the terms between the local distribution company and the pipeline are fair within their authority. I mean, of course, it's the commission's role to assess whether there's a need for the pipeline. When it's reviewing need, it considers agreements, but it's been the commission's consistent policy that it's not going to treat affiliates differently unless there's evidence offered of abuse. And that is different than how the commission approaches these sorts of agreements when it comes—
affiliate. Can you define or tell me what would be evidence of affiliate abuse in this context?
It's a little hard in the abstract because the commission said there's no evidence offered here, but I guess one way to look at it, Judge Millett, is maybe with the open season process. If you had an open season process and you had a company that wanted to bid for transportation service, and somehow was denied the ability to do so, and that party pressed forward with rehearing at the commission, I suppose that could be a potential issue where that party would say there was an open season, but it actually wasn't fair.
I don't know how the open season doesn't hurt you rather than help you, because Spire, Missouri didn't participate in the open season. If it really had a need, it would have shown up in the open season. It didn't. It wasn't. After the open season was an abysmal failure because nobody wanted this gas at all. Then Kazam, the agreement between the affiliate and the parent materializes. So I don't think that helps you. But again, I'm asking you, Ferc says it looks for affiliate abuse at this stage, or even just concerns about it. I'm not saying whether it's happened or not. It looks for concerns about it. I don't know how it can look for concerns if no one can tell me what they mean by affiliate abuse. Does it mean that we're using the affiliate to create need that wouldn't otherwise exist? Is that a form of affiliate abuse?
I suppose it could, but I think just to be clear, Judge Millett, the commission's not the commission is not going to dig into affiliate abuse whenever there's a potential for affiliate abuse. I think the concern that was raised by the Environmental Defense Fund is that these kinds of transactions are inherently suspect.
What more
And my
evidence
point
do you
is-
need? What more evidence would you need here when you have the affiliate relationship? It's the only agreement. The affiliate didn't participate in the open season of its own volition. This agreement appeared only after the open season failed completely. There's no cost savings. There are other pipelines if they want already in existence if they wish to diversify their sources.
I don't agree with a number of the premises.
Okay, all right. Which premise don't you agree with?
So first off, I'm not sure I agree with the point that the open season was a failure. I think what the commission said was that its concern with open season is that there's an opportunity to subscribe for service.
Did anybody say they wanted to subscribe to gas on this pipeline?
No, but that doesn't make it an unfair
If they had
process.
come to FERC looking for an authorization with nobody subscribed, that wouldn't have gone very well, would it?
I think the commission's point is that there needs
No,
to be.
they had to come with somebody wanting some of this gas, didn't they?
Okay, well, I mean, I guess
Is that
again,
right? Maybe I'm wrong. Does FERC approve pipelines where there's no contracts for it? Nobody wants it?
I mean, I assume that would not happen, but
Okay, so they had to come up with something.
okay. Well, I guess my point is that the commission's not focused on when the agreement, when a party decided to enter into an agreement. It's whether there's an opportunity for others to participate.
No, I understand.
That
Well, that's
happens.
what we're asking is whether when you have timing like this, does that make it? I understand the commission didn't look. I think we all understand the commission didn't look. The question is if the factors, at least that have been recited to you, aren't enough to have FERC at least express further inquiry.
I
What
think
more would you have to have? What more do they have to have? What evidence would be sufficient?
okay, so I guess let me put it this way to contrast this with the record we have here. So if the pipeline offers a number of rationales for a project and opposing parties come forward and respond, and those responses don't, and the commission and those responses fully address and rebut the pipeline's stated rationales, I think that could be something. That's not what happened here. And I think, Judge Millett, one of the issues you pointed out was availability on existing pipelines. Well, the commission made a finding that there was not sufficient available gas on existing pipelines. You can look at, for example,
Okay, yeah, do tell me that one, because I thought there were plenty of other pipelines.
there are other
The claim
pipelines.
wasn't
That's
that they
correct.
didn't have sufficient, that they weren't getting sufficient supply from Enable and these other pipelines. But do tell me where they found that
Right. So
this is the only way to get sufficient gas in.
So go to the commission finding is at JA 1019, paragraph 213. And the commission points out a claim by the Enable pipeline that it had existing capacity. And it says, commission found as
Hang on one second. Hang on. I'm trying to get to the same page you're on. Sorry, 1019.
paragraph 213, it's the second
Yep.
sentence. Judge
Okay.
Millett. The commission stated, as MRT, that's Enable, as their own comment notes, the East Line and the Illinois Interstate Pipeline do not have adequate available capacity to meet the needs of the Spire STL pipeline project. And the specific data that it's referring to.
No, but there were other pipelines besides Enable.
That's correct, but they're not all serving the same side of this service territory.
Where does it say that? Where does it say that?
So
Where did they analyze all these other pipelines as well?
So the data about not enough existing capacity on the other pipelines, you can find that at a few different places. There's JA.
I'm talking about the combined capacity here. I mean, they either want to diversify or they don't, but were they not getting enough from Enable? Was there insufficient supply from Enable?
That's one of the rationales that was offered by Spire that
No,
Enable.
but was that found by the commission that they were? I don't care what Spire is saying for this purpose. What I want to know is, did the commission find that they got to have this new pipeline because they aren't getting enough? I didn't see that anywhere. I just saw enhanced reliability and flexibility. Where is there? They don't even have enough gas coming through. Where's that?
I think what I just pointed you to, Judge Millett, the commission found that the existing options did not have adequate available capacity. And
To meet the needs of the Spire STL pipeline project. Where does it say to meet Spire, Missouri's needs?
Well, I don't think it says it that specifically, but the Spire, Missouri signed up for 87.5% of the capacity here. And if you look at the numbers,
but was Spire, Missouri in need? Were they not getting enough gas? They're the source of need. We don't ask whether the other pipeline has need. We're asking whether there's a need for someone to have this capacity that this new pipeline is providing. So I don't understand they don't meet the needs of the Spire pipeline project. Where does it say Spire, Missouri's needs weren't being met?
I mean, I'm not sure we
that would
have
have been the first thing. That would have been the first thing Ferc would have said, right? It didn't say it. Even in your paragraph 24, it doesn't say that.
Well, paragraph 24 does actually. That's one of the issues that's raised. It says the inability of current pipelines to provide an additional 350,000 decatherms per day, and that's what Spire, Missouri signed up for. And so if you look at
okay, right, an additional, but they don't have increased need.
There's no need to support it. There's no question that they'll produce more, but what we're seeing is they're producing more than is needed.
I don't know that it's more than it's needed. It's what the customer is asking for, and part of what the reason they're asking for it is to provide as we've talked about, the more diverse supply options to the region to replace expiring contracts and to replace an aging propane facility.
How's it more diverse if this is their only source of gas now?
It's not their only source of gas, Judge Tatel. It is, I mean, to be clear, that Spire, Missouri has gas coming in from, I think, the east side of its territory and from the west side. And so, for example, there are pipelines like, I believe the Missouri Gas Company provides gas from the west.
Let me just ask you an unrelated question about remedy. I know you don't talk about this in your brief, but some of the other parties do. If we were to agree with the petitioner here and believe that the commission's decision was arbitrary and capricious, do you have any view about whether we should, why we shouldn't also vacate the commission's decision?
I would say under this court's precedent, you should not vacate. Hopefully it won't come to that, but this is a scenario where, to the extent there's a concern about whether the commission can provide more explanation on remand, I think it could. And I think similar to...
What would give us confidence that it could?
Well, I mean, part of at least a big part of the argument that's been raised is that the commission only relied on the precedent agreement. And we pointed out we disagree with that based on what the commission has said in the record. But if the court thinks the commission can provide more explanation on that, it can remand for further explanation. I'll also point out that this is an operational pipeline that's been operational for almost 2 years. And so similar to City of Oberlin, for the reasons that court outlined, it would be disruptive to vacate at this point.
Yeah, I agree. We didn't do that in City of Oberlin, but well, let me ask you about the question of disruption. Couldn't the pipeline here simply go back to getting its natural gas from its previous sources?
I'm not sure we have a record to show how easy that would be, Judge Tatel. I know that this, as I mentioned, the pipeline's been operational for some time, and it's been receiving gas on Spire for roughly 2 years. So I think that could be a question that Mr. Franklin might be able to address, but we don't have a record for that.
The reason I'm asking is that, I mean, look, if we think that this record supports an inference of self-dealing, why would we allow the pipeline to continue? Why wouldn't we vacate the decision while commission figures out whether there is self-dealing?
No, because I think that you can remand to the commission. The commission can investigate the issue without having to go to the extraordinary remedy of vacature, I guess is our point.
To Judge Edwards or Judge Millett, either way, do you have any more questions?
No.
I had one. Oh, go ahead.
Go ahead, Patty.
You have one, Judge Edwards?
No.
So on your paragraph 24 in rehearing, one of the things that was credited, I mean, you just went through the list that Spire, Missouri said, and I'm trying to make sure, sounds like the commission credited all of them, and that was that it would move capacity or supply away from a seismic zone. Is that right?
Yes, that's one of the rationales offered by.
That's something of concern to the commission, the pipelines not traverse seismic zones?
I think that's certainly I think the commission's point here is that's a valid reason for a supplier to want to diversify its source of, not just the source of gas, but the path by which it receives gas.
Sorry, so it's the commission considers that a relevant concern.
I think that's among, yes, I mean, that's among.
That's a they listed it. And I said,
Sure.
they're sufficient. Okay, I'm not sure why you're arguing with me over this.
No, I'm not. I think my point is that this is among the rationales the commission
Yes,
found sufficient to overcome overbuilding.
So it's a relevant concern. Who authorized all these pipelines that are going over seismic zones?
Well, I assume the commission would have, but obviously that's before the time of this record. I can't sit here and explain
We know
to you.
who authorized all these pipelines over seismic zones. If you look at a map of pipelines across the United States and seismic zones, there's countless pipelines across seismic zones. This is what, in crediting this finding, did FERC mean that it was no longer safe to have a pipeline, that this is a real reliability concern? Let me phrase it that, not safe, but it's a real reliability concern if your pipeline crosses a seismic zone?
No, I don't think the commission was making that finding at all. I
wasn't
think
making a finding that was a real reliability concern.
I think the point here is that the commission is finding that these are the sorts of issues that, based on the record before it, it's not going to try to second guess the judgments.
So when it said here, these findings are sufficient to overcome concerns of overbuilding, they actually meant what they said in the next sentence is they've said this list of things and we're
Right.
not going to second guess it.
Right. Yes, that's exactly right.
That's all
Well-
they did here. Either, look, I'm asking you, either you meant it's a real reliability concern to have a pipeline that goes over a seismic zone, or FERC didn't. And you just said, your answer, as I understood it, tell me if I'm wrong, is that Missouri said it was a concern. And as the second sentence says, we're not going to second guess that.
That's what I've understood you to be arguing all along. And that rehearing, they weren't really making findings. They were saying, these have been asserted, we're not going to second guess them.
I mean, certainly there's no attempt in the orders to assess, by the commission, to assess the risk of earthquakes.
Or any of these things on the list.
Any of the
Well,
things.
that's not true. I mean, I pointed you to the capacity point.
Well, they listed seismic zone. Did they mean it or not?
I mean, that's one of the issues that they specifically said. That's up to the judgment of the shippers.
Up to the judgment of the shipper. Got it. Okay.
Okay, thank you. We will
Thank you.
hear from Mr. Franklin. Mr. Spire, is that right? Yep.
I'm sorry, can you hear me now?
Yep.
Yep.
Thank you. Jonathan Franklin, representing Spire STL Pipeline, the intervener. With me here at a safe distance is Chris Barr, who represents intervener Spire, Missouri. I'd like to start with what I think is a misconception about what FERC found in its original order. It did consider the allegations of anti-competitive conduct. What it said was we have a precedent agreement that would normally be sufficient in itself to show need, but it's between affiliates. So we're going to look and see if there is evidence having been presented by the petitioners below of anti-competitive conduct. And it specifically considered and rejected the argument that there would be unnecessary overbuilding. And it did so by relying on legitimate, non-pretextual statements of need that are undisputed in the record. And to your question, Judge Edwards, there's nothing in the opening brief of EDF challenging any of these needs except for footnote 2, where they say the propane peaking facilities was not a real issue because they were rarely used. And that's obviously incorrect. And it shows to me the precise reason why this was needed. The propane peaking facilities was one of the reasons that Spire, Missouri gave for needing an additional supply. It is undisputed, and the Council for FERC is correct, that the needs for that capacity, in other words, to be able to retire the propane peaking facilities, no existing pipeline could meet those needs. And you can find that, Your Honors, at page 101.8 and 101.9 of the rehearing order, which cites the environmental assessment at pages 769 to 772. You can also find it
I'm sorry. I just asked you to slow down a little bit because I don't know my numbering is the same as yours. So you said the rehearing
I'm sorry, the
order.
rehearing. I'm looking at the rehearing order at 108, 101.
Can you tell me what
101.
JA page? Is that the J? Because my JA
Yeah, the
is
JA, sorry, JA 1018 to 1019.
1018. Okay. I'm sorry.
Sorry.
Wait, no, hang on. Wait, so you must mean the original. Do I have the wrong
I
JA?
have
My
that.
JA
I
has
have it.
the rehearing starting on 11:44.
I'm sorry, that's the original order. Pardon
Okay,
me.
so
I said
that's
rehearing.
why I'm confused. Okay.
It's the original order. Pardon. 18
sorry.
18 to 19.
Hang on.
And
1018, right? 1018 to 109.
1018. Sorry, it's
Sorry,
the original order.
I'm not fast enough. Okay.
That's okay.
Okay.
And that is citing the environmental assessment, which you can find at pages 769 to 772.
Mm-hmm.
And then you can also look at pages 953 to 954 of the record. And this is the cost estimates that the Ferc was looking at. And my only point here, by the way, Your Honors, is to show that all of these cost estimates and all of the environmental assessment were based on the predicate that all parties agreed to, that in order to retire these propane peaking facilities, something new would have to be built. Existing pipelines simply could not provide that capacity. And this is important, Your Honor, because this is where it gets into the question of anti-competitive activity. What Ferc said is we are not going to second guess Spire, Missouri's decision to retire its propane peaking facilities. That's within the business judgment of the company. And what we're going to show is that what we're going to look at is, are there existing does the existing pipeline serve those needs? And the answer is unequivocally no. Existing pipelines could not.
Can I back up?
Yes.
Sorry, because I'm just missing something here. Where does it, I'm just not seeing it. I looked at it and I guess I didn't see it. Where does it say this is talking about replacing the propane?
It's talking about all of the benefits that the project would provide. So there are at least all of the benefits, and it's saying those could not be provided without additional facilities. So what MRT, who's no longer in this case, was saying was, you can do something else. You don't have to use Spire STL. You can build an additional loop onto the MoGas pipeline. You can use some of our facility. And what Ferc found, as a matter of fact, in the environmental assessment and at the pages that I mentioned, is no, you can't. You cannot do it without building additional facilities. And by the way, each of those additional facilities would have at least the same, if not more, environmental impacts. What Ferc did not do.
So I'm on paragraph 212, and what it says is staff found that use of these facility systems as an alternative would not provide a significant environmental advantage.
That's correct. But what my point is, even going before that, is to say that you couldn't, I'm sorry, in the logical analysis, that you could not meet the needs that Spire, Missouri identified, the legitimate non-protectional needs could not be met by existing facilities. And so Ferc's entire analysis on the environmental end of things was, let's look at the alternatives. And the alternatives all required building new facilities. But again, we're going with...
Are you saying then that even if there was no demand and you didn't even have a precedent, you had no agreement, no precedent agreement, the commission found that it would still be legitimate because of these other problems?
No, they found it best based on the precedent agreement, but what they found is there was no anti-competitive conduct because there were legitimate non-pretextual needs that could not be met by the existing system. And I'm going to focus really right now on one of the key ones, and that is the retirement of the propane peaking
Yeah, but we don't know that,
facilities.
we don't know, I just don't see anything here that lets me know what, all we have is, the commission says we accept the staff environmental assessment evaluation and elimination of alternatives, but we don't know what then. Does that mean they were finding everything was a problem?
What they were finding, Your Honor, was that the needs of Spire, Missouri that were identified, that were legitimate, non-protectional, and by the way, all of these needs were identified in Ferc's certificate policy. So I'm looking at
Well,
page
they were listed, right, that's, sorry, go ahead, tell me where you are,
I'm at 61748 of the certificate policy. And what they said in certificate policy, and this goes
hang
back
on,
to
what JA
1990.
page is that? Oh,
I'm
sorry,
on the JA. I'm at the
you're the
certificate
certificate
policy.
policy statement, okay, sorry.
Yeah, and it's quoted in almost every brief. And what they're saying is that just new demand isn't the only thing that justifies a pipeline. It
Right.
includes access to new supplies, providing new interconnects to improve the interstate grid, providing competitive alternatives, increasing reliability. Propane peaking facility, and this is in the record, Your Honor, is that at pages, and again, I hate to keep doing JA sites, but at pages 831 to 32, what the reason for retiring the propane peaking facility
Whoops.
is that
Well, hang on one second, what document is that? 831, 832?
831, 832.
What document is that?
This is a response that Spire STL, my client, gave to FERC
Oh,
in
okay,
response
that's not
to
the
this
commission,
question.
okay, all right.
And so what it shows is the reason they were retiring the propane peaking facilities is that they were the only LDC in the country that was injecting propane at times into the gas supply, but newer things like natural gas vehicles and high efficiency boilers can't use that propane mixture. It's too high. So they needed to retire that, and no existing pipeline could meet the demand. And the only thing that, and Judge Edward, this gets to your question, the only evidence of need that was a challenge in the opening brief was at footnote 2 of EDF's brief, and they said, oh, the propane peaking facility, that's nonsense because you only use it on occasionally. Well, that's clearly wrong. Propane peaking facility is necessary. It's required by the Missouri PUC. It is needed to supply gas on peak days. And here I'd like to give your honors.
Am I right? Wait, just to follow up there.
Yeah.
Am I right that it was used 3 days and 5 years?
It's something like that, Your Honor, and I apologize. I don't have
That's what the
that is in
commission
the
found.
record. Yeah,
Okay.
but that's
3 days
the
and 5
point
years,
of the
okay.
fact is
And did
that
it work those 3 days?
but they have to do it works, but what they have to do
It
is
worked
they have
those
to
3
give.
days. Okay.
But they would have to give notice, and the market is changing, and that's what what I said in the page that I noted is that more people have natural gas fired vehicles, and then there are these new high efficiency boilers. This is an aging system, and so what FERC said is we are not in the business of questioning whether or not an LDC, which we don't even regulate, has a need to retire its propane peaking facilities. We are going to look. We're not going to go behind that, and that was proper. But we're going to say that shows that they have a legitimate, non-pretextual reason for wanting to sign up to this pipeline that goes beyond demand. And if I could give you a real-world example.
Let me. Can I frame it up just a little bit before you continue?
Yeah, sure.
The policy statement to me is strange in the sense that it's kind of all over the place. But one of the things that I focused on at one point, it's at 61,747. Rather than relying on only one test for need, the commission will consider all relevant factors reflecting on the need for the project. The commission will do this. These might include, but would not be limited to, precedent agreements, demand projections, potential cost savings to consumers, or a comparison of projected demand with the amount of capacity currently serving the market. That's the commission's view. All right, so now what I'm trying to figure out is, apart from pointing to the precedent agreement, which is only one of the things listed in that sentence, where did the commission in its opening disposition with respect to the certificate analyze these factors and conclude that they all justified giving of the certificate? Where is that in the original statement by FERC?
I
Where
will
is
get
it?
to that.
Not
I will
your,
get to
not
that.
your, you kept referring to a lot of different documents, including submissions that you made. I don't care about what you submitted. I want to know where in the analysis did FERC go through those 5 or 6 factors and say, we've considered them all and this project should go forward. Where is that?
Can I answer that in 2 different ways, Your Honor? And I will get to the answer to your
No, I'd
question.
rather you give the
first,
answer.
The answer is they didn't need to, and this court has recognized that they didn't need to. I'm reading now from the Minnesink case at footnote 10. This court said that while the policy allows FERC to consider all of those things,
Right.
a precedent agreement is by itself sufficient evidence of need, and that's at
All
footnote
right. So
10
no,
of
wait, let me, the
Minnesink.
same way I
So-
press counsel on the other side. So you're suggesting that the precedent agreement, which is what we've been worrying about, is it? That's all that was required in this case? And they had a
No.
precedent? All right. Then
Okay.
where is there? The problem is we're all saying to you, whether you like it or not, facially,
Right.
it looks like this is a case where some kind of balancing might be required. Just common sense, intelligent people looking at this would say some kind of balancing is required. And the mere existence of a precedent agreement in this situation where there's no demand and an affiliate, I don't know whether there's a self-dealing concern. In any event, it reeks of, is there anything else? So that
Absolutely.
a precedent that you cited doesn't answer my concern, because I don't read the precedent to say where a case reeks of a need for more, FERC doesn't have to give it. I don't buy that.
I'm not selling it. Here's
Okay.
what I think Judge Tatel might have mentioned this before. Where there is a precedent agreement between affiliates, FERC does require more and did require more in this case. It
Okay.
requires
No,
excuse me,
well,
it requires John, it requires FERC to find that there's no evidence of affiliate abuse or anti-competitive activity.
No,
And
now
that-
I want to, Mr. Franklin, I want to interrupt you. That you're making the same argument that FERC counsel made. The petitioner's argument is that FERC's acknowledgement of A, no market need, and B, no price benefit was by itself sufficient to impose on the commission an obligation to look deeply into this to see if there was self-dealing. That's their argument. And based on our caseload, that seems to make sense to me. And what we're all asking you is we can't find in the commission's original order where it did that.
And do you agree with Judge Tatel's premise that in that situation, FERC is required to do more?
I agree that the FERC was required to look for whether there was evidence of anti-competitive conduct, and it did that. It did something extraordinary in this case. It found that the pricing, it actually asked for pricing
Wait, can I
information.
just clarify one thing? You said anti-competitive conduct. That's not necessarily the same thing as
Yeah, it's not.
affiliate manipulation. So can you rephrase your sentence in responding to what we've been
Both.
concerned about? Okay.
So they had to look for both anti-competitive activity and affiliate abuse, and they did look for both of those things.
They didn't. Wait, that's the point.
Where do they say they looked?
Where do we find in here what the evidence looks like is that basically, since there is no price benefit, that the benefits of this things go to the shareholders, not the customers. And you don't have to look for any other evidence than that. So why isn't that by itself enough to impose on FERC a burden to explain why they're doing that?
And they did, and I think they did it
Where?
at pages 968.
Say that
pages
again. 968?
968 to 969 of the record. So that would be paragraphs 83 to 85. And this is the original order, not the rehearing order.
Right.
And this is where they said The other side, and this is still EDF's argument, at page 22 of their brief, they say there is no rational explanation for this decision to sign on to the project except for advancing the corporate enterprise's interests. And Ferc looked at that argument and said, no, there is a rational explanation, and the rational explanations are severalfold. This is enhancing reliability, enhancing getting new gas from the eastern part of the country that it could not get before, that doesn't go through an earthquake zone, that doesn't travel hundreds of miles from the south. And if I might, Your Honors, I'd like to read to you.
Wait. Can I just, you're talking about 968. That's where they recite Spire, Missouri's reasons, and they say all of those issues fall within the scope of the business decision of a shipper. The commission's policy is not to second guess the business decisions of pipeline shippers. Unless there's evidence of affiliate abuse, and they don't do anything more. So how is that showing that they thought there was affiliate abuse and looked for more?
They didn't think there was affiliate abuse, and there was no evidence of it. But what it does show, if I might continue, I'm sorry, Your Honor, I don't want to talk over you. The reason Ferc was correct not to go behind and to second guess the business judgment, I'll use the propane as a good example. Ferc is not in a position to tell a gas company it cannot retire its propane peaking facilities. That is within the business judgment of the gas company. That is something that Ferc is not going to second guess. What Ferc is going to do is saying, you have said you want to retire your propane peaking facilities. We have found, and I cited you the pages, and there are other ones as well, we have found that that cannot be accomplished. It cannot be accomplished without some new facility. So the pipeline serves that need, and it shows that the precedent agreement is not merely an anti-competitive grab to enrich the company at the expense of the ratepayers. And if I might, I just want to sorry.
We're going in circles. We're trying to figure out this. Judge Tatel a long time ago said, look, you have a situation where it's conceded there's no new demand, and it's conceded there will be no cost savings from this project. And that raises our eyebrows. Now, I don't know whether it raises an eyebrows about self-dealing, but it raises an eyebrow for me about needs, and it certainly picks up on some of the points that are in the policy statement. And you seem to be agreeing that, yes, Ferc has to respond to that. And then you say their response is, we're not going to look at what's been asserted to answer that question. That's not an answer.
It is an answer to the question, because the argument below, Your Honor, the argument below was that, and it is still the argument on appeal, there is no other rational explanation for this pipeline except anti-competitive activity. And Ferc looked at that argument. The argument is there is no other rational explanation. And Ferc said, no, there is. And if I might, I'd just like to read to you.
Is that what you're going to read to me?
Well, no, Ferc said that at the pages I just gave, 967, 968. They said,
I know you want to read your other thing. I do want to let you do that. Can you tell me where they say there's no other rational explanation for this?
They said that there is a rational explanation for it.
Oh, I thought,
that's what I'm saying.
Where they say there is a rational explanation?
Yes.
Now let me tell you what's going through my mind. You say there is a rational, and then you're going to say they recited the evidence offered by the proponents of the project, and then they follow that by saying, and we're not going to look to see whether that's right or wrong because that's their call. That is an argument. I don't know how you characterize that, but that's not a winning argument. There is a rational explanation, but we're not going to check it. That doesn't make sense to me. No. That's
the other side.
The other side is obviously going to say, yeah, we think we're right, and Ferc's not going to look to see whether it is in fact right.
They weren't. None of these things were disputed, Your Honor. None of these benefits were disputed below. The only argument was you could achieve them through a different series of other pipelines that could have been built.
Okay, so
There was
let me hone this down in my mind, because this is what I was raising with the other side as well. Is your argument that the justifications that you offered from the get-go to support the project have never been contested by the petitioners below or now? That they really have not made a claim that there's no evidence to support those justifications, and the justifications were there, uncontested, FERC has to do nothing more. Is that right?
Your Honor, that these needs could not be met by existing services, yes. And the only argument that's made in the opening brief is at footnote 2, and that relates to the propane peaking facilities. And that argument is clearly wrong, because the fact that they didn't use them very often doesn't mean they didn't need them. And if I could just, this is what I want to read, Your Honor. This is from page 833 of the record. And this is when, same part of the record I just identified before. This is Spire's giving to the commission its explanation for why it needs the project. And one of the key things it said is it's a reliability concern. And it said we need it because, quote, regional events such as supply freeze-offs, major storms, or extreme cold can create significant regional price spikes in the cost of gas that can be mitigated or avoided completely by having access to multiple differing supply basins in differing geographical regions. That is undisputed, Your Honor. There's no dispute.
Yeah, but what the commission, Mr. Franklin, what the commission said in response to that was that's the company's business decision. We're not going to look behind it.
Right, but there was no dispute, Your Honor. There was
your claim is that those justifications were never challenged. That's the heart of your argument.
It is a very important part of our argument.
No, I understand the argument. I want to make sure that I'm hearing you now. That's the crucial part of your argument. If there is some claim here, they never contested what we offered, and we clearly offered something.
And I'll go even further, Your Honor, and say they didn't contest it on appeal in their opening brief, for sure.
Well, I raised that. Okay.
And I will tell you that it is widespread public knowledge that exactly what I just read to you happened last month. There was a freeze up in Texas where gas supplies literally froze up at a time of peak demand, so that the Texas governor issued an order saying gas cannot leave the state of Texas unless it is not being used to supply electricity there.
I thought the Texas governor said the whole thing was because of the wind turbines failing.
No, it's actually the gas was incredibly important. And
he didn't say that? He didn't say that? I thought he said that the whole problem was because of the windmills thing.
Well, the order that he gave was about gas, Your Honor. The order he gave was saying no gas can leave Texas unless it can't be used for electricity. Now, if the petitioners had had their way, the Spire STL pipeline would never have been built, and the city of St. Louis, the entire metropolitan area, would have remained captive to the MRT system that drew gas from those same areas, which meant that exactly what was predicted at page 833 of the record would have occurred.
Can I back you up to?
None of this is in the record. I mean, we can look at the record and make our own judgment about whether, as you say, the petitioners never challenged it.
Exactly, Your Honor. But my point is this: no market study that FERC. So they're saying you have to do a market study. No market study FERC could have done would have predicted that there would have been record cold and a gas crisis in Texas in the year 2021 for 3 or 4 years later. That's the business judgment of the company. But what FERC did say is we're going to look to see, are there legitimate non-protection...
Did the pipeline, did your client say, look, we need this new capacity because the system might freeze up in the future?
Yes, that's exactly what I read to you at page 833 of the record. Exactly, those exact words, Your Honor. In those exact words. And the reason was 834 of the record, it had happened before in 2011. And the point I'm making is that FERC said, we're not going to second guess the company's business judgment on these things. Now, if the other side had said, this is it's a load of hooey, it's never going to happen, it couldn't happen, there's no reliability issues, then the FERC might have looked at it. But they never did that. And they certainly, Your Honor, Judge Edwards in particular, they certainly haven't done it on appeal.
All right.
They have nothing in their...
Can I back you up to
Yeah.
page 832?
Yes.
Paragraph C,
To find that, Your Honor.
page, I don't know if 26 makes you feel better, but it's JA 832, so it's the page before the one you've been talking to us about.
Okay, I'm getting there. Yes, yes, I'm there.
In paragraph C, second line. The decision has already been made to retire the propane system. So that was made before
Oh,
there was it sounds to me.
yes, but they
So
couldn't do it without.
let me just finish my question. The
Yeah.
decision had already been made to retire the propane system before this Spire pipeline came along. And is
No,
the reason they want, oh no, that's not what it meant. It hadn't already been made to retire the pipeline?
that's what they wanted to do, Your Honor, but they couldn't do it without the
Well,
Spire STL
then
pipeline.
why didn't they show up in the open season saying, we need this? Ferc, you're all wrong. This isn't, I know needs flat. We need this to replace our propane system. Why didn't they show up in the open season saying that?
They said it in their application to FERC. It's one of the key things they said, Your Honor, and they were in the open season. They already had a precedent agreement before the open season. This is
No,
the
that's
key.
not what the record said. The record said the agreement came out after the open season. May have started talking before the open season, but the record says the agreement with Spire, Missouri came after. All right.
Around the same time as.
So the evidence says, because all we say is they had already planned to retire this propane system. Did they have any other? So you're saying they didn't have any? I just don't know what has already been made.
What I am saying, Your Honor, is they could not do it. And they only recently, it's about 90% retired now. They could not do it. They could not do it without this pipeline. So if FERC had denied them the approval they were seeking, they would not have been able to retire the propane peaking facility.
And it says that they could not, this was the only way, is said where?
It's not the only way. So MRT, and gets back to those pages that we were having trouble with finding earlier on. There were other alternatives offered by MRT, but all of them.
But not just MRT, there's other pipelines too, including some that connect to REX. That's why I'm rather confused.
Right, but FERC rejected all of those alternatives in its environmental assessment.
No, it didn't reject them. It said they didn't provide significant environmental advantage. It didn't say they weren't doable or even more cost efficient.
The point I'm making now, Your Honor, is a more fundamental one, and that is that the existing pipeline systems, the ones before Spire STL, could not give the demand that was needed to retire the propane peaking facilities. They could not. All of those alternatives that we're talking about, the ones that were evaluated in the EAs, they all involved building new facilities, looping other pipelines, putting additional pipelines through. The existing systems could not handle it, and that is undisputed. Mm-hmm. There is no dispute, and nobody can give it to you because it's not there. The capacity that was needed to retire the propane peaking facilities could not be provided without on the existing system. So there was a need for this pipeline. They had shown a necessity for this pipeline. Then they looked at the environmental impacts and said, we're evaluating the alternatives. What are the alternatives? All of them involved building something else. That's why the no action alternative was rejected. They all involved building something else. And we're going to say, in our expert judgment, the Spire STL pipeline, which doesn't cost materially more, is sufficient. So it is, in fact, exactly what you want FERC to be doing. You don't want FERC to be coming in, and frankly, I'm not hearing Your Honor saying that this is true. You don't want FERC to be coming in and saying to Spire, Missouri, you've told us you want to retire your propane peaking facilities. And Judge Millett, as you said, they'd already made that decision that they wanted to do this. This court is not in a position, and FERC is not in a position to tell the company it can't do that. You have to keep the stuff in place when you're telling us that it has operational difficulties. We're also saying you're telling us you need reliability because there might be a major freeze-off or a storm or cold weather, page 833 of the record. FERC is saying we're not second-guessing that because nobody has told us, and there's no evidence, that that's a pretext, that that's some sort of a made-up thing. And what FERC is saying is, yes, when there's an affiliate agreement, we're going to look a little bit more. We're going to say, is there evidence of self-dealing or is there evidence of anti-competitive activity? Here there was not, and there was not because there were legitimate, unrebutted, non-pretextual reasons for doing this that could not be met by existing systems.
Oh, okay, Mr. Franklin, I think, unless either of my colleagues has another question, I think we've got your argument. So,
thank you,
is that right? Judge Millett, Judge Edwards, are you okay?
Yes.
Yep.
Yes.
Okay, so, Ms. Karras, you can take 2 minutes,
Thank
and
you,
Mr. Robertson, thank you, and Mr. Robertson, you can take this.
Thank you. So I just want to clarify one point. Our opening brief attacked what FERC said was its rationale regarding need. FERC said it relied on the contract. It had to do more because the contract is supported by captive customers. On FERC's brief, for the first time, it said these factors were extra contractual evidence of need, and our reply brief rebutted all of those. The Supreme Court explained in the Atlantic refining case that because the Commission's task under Section 7 of the Natural Gas Act is so crucial and has such far-sweeping consequences, if there is a situation where an application probably would not be in the public interest, a certificate should not be issued. Here, as Commissioner Glick explained, the record is patently insufficient as there is neither evidence that the Spire project is needed, nor that its limited benefits outweigh its harms. FERC is supposed to act as the guardian of the public interest. Its blinkered reliance on precedent agreements to satisfy market need has gone too far in this case. The viability of existing pipelines is threatened. Captive customers now pay higher rates, and EDF's members' land has been taken and damaged while Spire continues to pay itself millions of dollars per year based on an unneeded and legally unjustified project. We respectfully ask the court to vacate FERC's orders to ensure this damaging precedent does not stand. Thank you, Your Honors.
Thank you. Mr. Robertson, do you need a minute or not?
Yes, please. I disagree with Mr. Franklin regarding the no action alternative. It was not denied by FERC because it didn't build anything, but because FERC defined the project in exactly Spire's terms, which they are not allowed to do. This is an example of the procedural injury that we suffered. The EA, the certificate order, the order under hearing are a medley of inconsistent and contradictory justifications for evading NEPA. And for example, they simply refused to consider the climate impacts that we were trying to challenge because they define cumulative impacts as necessarily local. But global warming is global in nature and must be considered in that context. And I'll leave it at that. Thank you.
All right, well, thank you. Yeah. So the case is submitted. Thank you all.
Case number 20-5094, Fisheries Survival Fund et al., appellants, Garden State Seafood Association versus Scott de la Vega, Acting Secretary of the Interior et al. Mr. Frula for the appellants, Mr. Smeltzer for the appellees, Secretary of the Interior and Bureau of Ocean Energy Management, Mr. Super for the appellee, Equinor Wind US LLC.
Go ahead. You can proceed. Yeah.
Good morning, Your Honor, and may it please the court. I'd like to reserve 2 minutes for rebuttal. I think I had 10 altogether. We represent the fishing communities, associations, and businesses whose interests were immediately adversely affected by the lease of an area offshore New York for offshore wind development, twice the size of the District of Columbia. The lease was made by the appellee secretary to the appellee intervener Equinor. On December 8th, 2016, we filed suit to enjoin the lease auction for this wind farm under NEPA and the Outer Continental Shelf Lands Act. The final sale notice had been published on October 31st, and the lease sale had been set 45 days later. The government and the interveners have argued, and the district court below concluded that the lease and the lease auction were, legally speaking, a non-event, and on that basis disposed of our NEPA claims on ripeness and our OXLA claims on failure to provide 60-day notice. The district court erred on both counts. It's simply not the case under OXLA on our counts 4 and 5 that the lease is a non-event. It's clearly an event. The lease program is the main purpose of 43 USC 1337 P1, the Energy Policy Act amendments of 2005 specifically set up leasing as the signal element of the new program to provide authority for BOEM to conduct offshore leasing. And subsection 1337 P4, which provides for consideration of impacts on other users, specifically applies to any activity, and certainly a lease is any activity. The court found we had standing, but barred the claim for failure to provide 60 days notice. And the fundamental issue here is that BOEM pushed the lease sale through during a presidential transition. There was only 45 days between the final sale notice and the lease auction. Generally, yes, claims under the OXLA are supposed to be provided 60 days in advance, but there's an exception set forth at 43 USC 1349A3 for a legal interest immediately affected. Under OXLA, the appellants have a legal interest and their residents have legal interests in fishing and navigation. That's expressly set forth in the
the problem for you is the ripeness disposition on the first part of the case really is damaging to you on the argument that you're making now. Nothing has been done to affect what you're complaining about, which is the possibility of wind farms. That has not been granted. This is a right to first refusal, as has been said. That's there isn't any. That it seems to me the record is absolutely clear on that. They have not been granted permission to do what it is that you complained about. They have not.
Yeah, another way to put Judge Edwards' question is, why isn't this case totally controlled by Peterson?
The court...
That's what he's asking you, basically. I mean, this is exactly like Peterson.
Well, Peterson needs to be...
They said there, you know, the question in there was, the question in that case was an energy lease. It's different there. But they said, our court said that they didn't mature, or that they weren't triggered if the lease, I'm quoting from Peterson, if the lease reserved to the government both the authority to preclude all activities pending submission of site-specific proposals and the authority to prevent proposed activities if the environmental consequences were serious. That's this case.
Right.
That's exactly the case under the lease.
And that makes perfect sense as applied in the oil and gas leasing case. But we have a different...
How could it be different for this kind of lease?
Because in the offshore wind... I'm sorry?
I mean, that's like saying the name of the case is different.
There are three principal differences, though. The first is the difference in the investments that go in before
so we're looking at
any decision is made on the construction.
Constitutional principles here. That's what we're talking about. We're talking about ripeness. It doesn't turn on the amount of money that's invested. It turns on whether or not there's any injury at this point, whether or not there's any obligations that have been triggered.
Well, the court, under ripeness principles, also can consider hardship and needs to look at the actual facts that BOEM was confronting. In this instance, hundreds of millions of dollars are going to have been spent on leases, on site assessment, on construction and operations plans. And
I'm sorry, I thought you said in your brief it was 42 million.
it's 42 million plus the costs for site assessment and construction and operations plans. That's all the costs that will be incurred before BOEM makes any decision whatsoever under NEPA beyond simply a decision on the site assessment plan that we've already seen with an EA. And what we're saying is that it defies reality to think that after you have gone and spent all that money, made all those years of investments, that BOEM is going to turn around and say at that point, wow, we really put this lease in the wrong place all along. That defies reality, and that's the tension here. I can understand that BOEM did not want to have what happened to Cape Wind happen again, where they ended up in years of litigation. They restructured their processes, they restructured their lease forms, but the court can't and shouldn't look at this and not acknowledge reality. And the other point that the appellees are making is that this is simply a right of first refusal, as you said, an exclusivity point. But exclusivity alone doesn't solve the issue. I could say to you, Your Honor, you would like to buy one Powerball ticket and you're the only person in the country that's going to buy that Powerball ticket. You're not going to do it because you spend $43 million to buy it. You're still not going to buy it because you need to get all 6 numbers right. There's an exclusivity needs that comes with expectations.
How's that different from Peterson?
I'm sorry?
How is that different from Peterson?
In Peterson, there are hundreds of oil and gas leases that are issued at the same time. The costs up front are fundamentally different. It's just a fundamentally different set of leasing criteria and leasing standards. You're not spending hundreds of, tens and hundreds of millions of dollars up front. And those practical realities have to find the way into the court's analysis at some point, because what we're saying fundamentally is the most important issue to the stakeholders in the fishing community. The most important issue is the location of the lease. And the location of the lease is not going to be considered in any sort of detailed way until the construction and operations planning. And what we're saying is that if you do that, you're never going to get a fair shake. You're never going to get fair consideration of the location. And this location was decided back in 2011 when.
Why? Because you think the government agency wouldn't have the guts to back away when at the next stage they were convinced that this cannot be justified. I mean, that's the heart of your argument. We can't trust the government. Is there any case that says that we can't trust the government?
No, there's no case that says that exactly, but you also haven't had a situation where, again, the leasing process has been, BOEM went and it looks to me like they went and they read Peterson and said, let's set this up this way so that we can fall under Peterson. That's great, but what they've done is they've turned the oil and gas leasing process on its head, because normally in the unsolicited, in the gas context, leases are, EISs are conducted at the lease phase for non-surface occupancy leases, where the presumption is that there's generally going to be an EIS. And the same thing should hold here, is that you can't just say that everything is an exception to the general rule that with leases, there should be a fulsome consideration of the location up front.
Are your clients currently still fishing in their fishing areas? Has that been disrupted?
They're currently still fishing in those fishing areas, yes.
It hasn't been disrupted yet.
Hasn't been disrupted yet.
Okay.
And what we're saying is that these matters need to be dealt with up front.
Yes.
It's just fundamentally different.
Right. And so your position seems to be that as a practical matter, at some point before, assuming there is an approval of the construction and operation plan, at some point before that, the agency will have made a firm decision to allow some amount of service disturbance, or at least enough construction disturbance that's going to actually impair these fisheries, right?
No, we're not making the argument about the site assessment plans. What we're saying is,
I'm not talking about site assessment. I'm talking about, I thought your argument was, come on, we all know the forward momentum isn't going to be stopped at this point, at least in the way that you want, which is a wholesale ban on, I take it you guys want a wholesale ban on fishing in this entire area.
what we want was,
Not fishing, I'm sorry, wholesale ban on construction of a wind farm in this area.
what we want is a full and fair environmental consideration of fishing there. We never said we wanted a ban. What we said was we wanted the analyses to be conducted. We think if the analyses are conducted in a fair way, that BOEM will look someplace else to lease.
So all right, so just to clarify then, so your position is that if a full environmental assessment is done, it's not that they could adjust something about the construction to sort of balance, where they put the wind turbines, but that in fact, there's no way to adjust the construction plan or to modify a construction plan that wouldn't have overwhelmingly deleterious effects on the fisheries?
We're saying that there's no record basis to show that it won't.
No, but I'm asking a predicate question, and that is because this makes, at least for me, at least it's relevant. And that is, if the question here is, look, once they've got to do this comprehensive study, and once they do, they'll be able to tailor this project in a way that will balance the power interests and our fishing interests. That's one approach. Another one is they need to do this comprehensive study, because once they do, it's going to reveal no balancing in the construction and operation process is going to work. Having a windmill farm here at all is going to irrevocably and quite seriously damage our fishing. Which of those is it?
It could be either.
It could be either.
It could be either. It could be that that you could set it up someplace else, partially or more fully, but that was never analyzed in any. You're
saying you understand you can lose it, but you feel like it is so important that it must be done. And if it's done honestly, we'll see what happens. That's what your argument is.
That's what our argument is.
Okay.
And then,
well, I don't say, again, I'm not making honesty allegations.
No, that was just.
No, I just want to make sure.
Don't overread that word. You're saying you're entitled to an honest process.
We're entitled to a process. It's not where the dice aren't loaded against us.
That's exactly, I understand. Okay.
Okay. Anything else?
No, thank you.
Okay, thank you. We'll hear from the government.
Good morning, Your Honors. May it please the court. John Smeltzer for the Bureau of Ocean Energy Management. Your Honors, we believe the district court's judgment should be affirmed because the plaintiff's claims are not right and because plaintiffs failed to comply with OXLA's 60-day notice requirement. With respect to NEPA rightness, I think the court understands our argument. It is based on Peterson, and the argument is that Peterson controls. And Peterson controls because the lease in this case does both things that Peterson identified as necessary to do in order to delay or defer NEPA analysis. And when both those things occur, then there has not been an irreversible and irretrievable commitment of resources.
What about counsel's argument that when we look at rightness, we also look at hardship, and the hardship situation here is just dramatically different than in the oil lease situation?
Well, there is no hardship until the construction and operations plan is approved, of course.
No, that's not as.
They've invested $42 million that they're going to lose. Right.
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 Well,
So
if you're talking about,
he's making a perfectly plausible argument. The likelihood that are getting what the law in their view requires, that is a fair assessment of the project, full and fair assessment, is dramatically reduced when this much money is being put into it at the front end. And that is a perfectly plausible argument. This is millions and millions of dollars. I'm sure the three of us preparing this case separately scratched our heads and saying, right of first refusal for that many millions of dollars, and you may just go down the tube. They're saying, no, they're not likely to go down the tubes. And that's exactly our concern, that we are entitled to a fair process now.
sure, Your Honor, but this process was transparent from the beginning. The terms of the lease were known to.
But they're saying they're saying it's transparently unfair because you are allowing someone who is investing millions and millions of dollars to get a foot in the door, and this this claim of a right of first refusal is a joke in their view, because the likelihood of their prevailing now, having invested so much, is really great.
Well, Your Honor, as I think the court mentioned, there is no law that says that you pay more for the lease and therefore you need to do an EIS if the lease meets the Peterson factors. And what I was trying to say is that there is a presumption of regularity, of course, with how the government operates. And the government was, in Boehm here, was perfectly transparent in the terms of the lease and in identifying the risks throughout the stage, throughout the process, prior to the lease, and identifying to the potential bidders the risks that existed with respect to potential impacts to fisheries. That was transparent, identified throughout. If there had been a guarantee in the lease, Your Honors, the price of the cost of the lease probably would have been well above the amount that was bid on this lease. The lease does not have a guarantee. There is, of course, a sense on the side of the folks that bid that there is a true prospect here, and they are bullish on the opportunities. But Boehm did not guarantee anything. The lease language is perfectly transparent that if there are conflicts under the OXLA provisions under Section 1337P4, or if the Boehm determines that there are unacceptable levels of environmental consequences in that context, that a development plan will not be allowed.
Go ahead, finish your sentence. I'm sorry, you had a but.
I was just going to say there is the ability to examine different alternatives on this leasehold and to mitigate impacts. And one of the things Boehm determined when they identified this area and decided to go forward with the entire area and not cutting off particular areas from the beginning was that this would not necessarily cut off all access to all fishing, right? There are ways to mitigate impacts and do different things. And what Boehm said is we need to study those first in an environmental impact statement. And that's why we're going forward with this area.
It seems to me, so one of the arguments though is that it's not going to work. You just can't do it in this area. These things are too big. You're not going to be able to tweak it and adjust it here and there. These things are too massive. And you haven't seriously considered just doing it somewhere else completely. So I get that you're saying that we can do our environmental study and we can maybe rejigger things and adjust things and ban it a little bit here and make the pylon go over there. But I want to ask you as to the foundational question of whether a wind farm should be built in this 127 mile square area, period. Is that part of what will be reconsidered at the construction and operation study stage?
Absolutely, and that's part of the two parts of the Peterson test. It's preserving not only the ability to pre-approve or to approve any site-specific plan or any groundbreaking activity. All oil and gas leases, all federal leases in this area generally have that provision. Like the government, the lease itself doesn't allow the groundbreaking activity. The government has the opportunity, the agency has the opportunity.
You have the opportunity, but how?
But in this lease, well, I'm sorry, I don't mean to talk over you, but this lease has the second part, right, where it has the second provision that specifically matches what is said in Peterson. In addition to reserving that pre-approval, Boehm here has reserved all of its authority under OXLA, all of its authority generally to say no to the project if it will have unacceptable environmental consequences. And that's the difference between this lease.
Okay, That's important. But my other question to you is, what if the Bureau says go forward, and then a court, upon reviewing the environmental impact statement, says you've committed very serious error and not considering doing it somewhere else completely? And all this money has gone into it. Maybe construction has even gone forward at that point. It's a very separate question of not whether the Bureau could decide, but what's the Bureau going to say when a court says vacated and all that money and effort has gone in? Is the government going to agree that's perfectly legitimate thing for the court to do because we had no commitment and this company can't depend on there being a commitment?
This is a ripeness case, and so yes, that's the position we're taking. We're taking the position
We've
that
had this before. I mean, Judge Edward asked for a case, right? I've been on a case with Judge Tatel before where the government came in and said, don't stay anything, don't stay anything. We promise that if you find serious enough flaws in our environmental impact study to warrant vacature, we'll be able to undo everything then. And then when we found very serious flaws in the environmental impact study that warranted vacature, the government and the company came screaming in, don't vacate, don't vacate. Look how much has already been invested here. And how do we know that's not what's going to happen as a practical matter under these types of leases, the way this is arranged? That is my real concern.
Right. Well, first of all, there will be no construction and operations activities until there is the full NEPA EIS process done on that. So
no, does that include full judicial? I get that you might come back and say don't do it. I'm concerned about what this process is going to allow is that our ability to do anything other than go along with an EIS or say remand, but we're not going to vacate because so much literally water here is under the bridge. Or under the turbines, whatever you want to call it. So much water is done, so much has already been done. It's too much for us to give them the relief that, not to put words in their mouths, but if their argument is you can't do it here at all, that decision is no longer on the table. So what I want to hear from you is not that you're not going to make the decision until you think you've done a sufficient environmental impact study. What I want to know is what's the government going to say if the court, and it may never happen, to be clear, but if the court disagrees and it's the type of error that warrants vacature, isn't the reality going to be that you're going to oppose vacature just like you did last time on the grounds that too much has already been invested?
Right. Well, I guess the point I was trying to make, Your Honor, is right at the moment that the environmental impact statement is completed and BOEM makes a decision to approve or disapprove the construction and operations plan, it is at that point that if there are serious flaws, Mr. Froelich can come into court at that point and bring a new case. And it's that case.
Again, then.
Yeah, but see,
go ahead.
Let me just pick up there because I have the same concern Judge Millett had, but I've actually taken a different lesson from the James River case that she's mentioning, and we just had another one last summer with Standing Rock, the pipeline that. Oil pipeline that goes from Idaho to the Midwest. In both those cases, we had defective environmental impact statements, yet the construction was proceeding. The lesson I take from those two cases is that this court ought to be entering injunctions whenever anybody makes a serious challenge to an environmental impact statement. We ought to be enjoining the construction. And when we do that, the government agencies are going to scream bloody murder, right? They're going to say, oh, no, don't enjoin the construction of the project. We can fix the defects. That's what's going to happen.
Judge Tatel, that's the question for the next case. There's no way for me to stand here and tell you, what the defects in the environmental impact statement are going to be.
You're talking to a court that's had some serious experience with this problem in the past few years. And the lesson I've taken away from this is that we ought to be very serious about enjoining the construction of these projects when someone makes a serious claim about the adequacy of the environmental impact statement. That's the point to prevent any future, the kinds of things we face in the James River and the Standing Rock.
I might disagree with that as an across-the-board determination, but again, it's a determination for the next case. It is a determination.
I'm just letting you know what my reaction is to all this. So I mean,
Well,
your point is.
Understood, Your Honor. It's the difficulty here is, of course, we don't have the record before us of what are the impacts on these fisheries. What kind of limitations on access will there be? What kind of impacts on, their return on their fishing licenses and their ability to fish will there be? What kind of mitigation can there be? Until all of that is sorted out through a robust environmental analysis, which BOEM still has to do, it's very difficult to talk about, should there be an injunction or not? And of course, I'm not going to agree on behalf of the government that all projects should be enjoined.
I wasn't asking you for that. Come on, that was not the point of my question. The point of my question was to try to explain to you why at least two members of this panel who have just had these cases are concerned about the implications of these things. That's all.
And I take your point. My client will understand your point in terms of the analysis to come. This case ultimately, though, is a case about rightness, and it's a question about whether a NEPA claim should be heard by this court right now before the fulsome analysis is done. And the Peterson precedent is clear; it controls.
Let me back up then. So my understanding is this case has progressed while the litigation has gone on, which has been the problem in the past as well.
Sure.
And that you're already at the reviewing a construction and operation plan. Is that correct?
As my understanding is, there is a plan that was submitted. Mr. Super may have.
Their brief says that they've already submitted it.
Today, there has not been a release of an environmental impact statement yet. But
the government is actually going to do an environmental impact, a full EIS for that.
That's my understanding. Yes, Your Honor.
Okay.
Anything else?
Does the government agree? Would the government agree? Because the difficulty here is this, litigation. Sorry if I'm correct. Has to go through a district court and up to this court too, and so that means there's a lot of time and a lot of construction that can happen again before they're ever going to get this fundamental question that I take to be the heart of their objection, is that it shouldn't be in this area at all, is going to get resolved.
Well, BOEM hasn't
construction to go forward while there are challenges to the EIS,
and BOEM has not made a decision that construction can go forward, right? So that's the fundamental point about this case and why it's not right. Okay. If BOEM does make a decision, the government and it's challenged, right, then it will depend on the nature of the challenge and the merits of the challenge, and we'll just have to assess it at that point.
Well, let me ask you this way: if there's assuming they comply with all your regulatory legal requirements, it's easy if they don't. But assuming they comply with all those, their plan complies with all of those. If it does, is it at least predictable that a wind farm will be built in this area? We don't know the precise contours, but if at least they comply with regulatory requirements, is it predictable that a wind farm will be built in this area?
Well, Your Honor, I'm not going to handicap the likelihood of construction. BOEM hasn't decided, and I'm also not going to say that.
So it's not predictable, even if they comply with all the regulatory requirements.
Right, but when you say whether they comply, I mean, there's compliance in the form of providing all the relevant information to assess the impacts. But when you're talking about the statutory factors under Section 1337P4, in terms of balancing impacts on fisheries versus the benefits from the wind farm and other uses of the area and all those sorts of things, it's not a mechanistic checking a box.
I'm just asking, is it predictable that could be the outcome? I'm not certain. No, you're not agreeing. You're not. Of course, you're not signing off on anything. Is it predictable?
BOEM would not have leased this area, right? Would not have chosen this area to offer for a lease and to give Equinor an exclusive right to present a construction and operation plan if BOEM didn't think there was a decent possibility that the project would go forward. It wouldn't be in good faith to do so. So for sure, the industry is bullish on the possibility, and BOEM leased this area in the view that there was a good chance that they could find a way of making this work. But I feel like you're trying to walk me into providing some sort of guarantee, and that's exactly what
I want to be absolutely crystal clear. It's not what I'm trying to do. I'm just asking about, is it at least predictable? And I asked that, and I thought it sounds like it is. You're not signing off, you're not guaranteeing it. There's got to be some sort of serious, reasonable possibility that this is going to work here. No guarantee.
Yeah, sure. BOEM wouldn't have not put the area out for lease without doing the threshold, review, determine, right. and
exactly.
That's the point I was making earlier. It's in the record that there's potential fisheries impacts, and the extent of those potential impacts is in the record. The request of Mr. Fuller's groups to isolate and to set apart particular areas of the lease because of particular impacts on scallop and squid fisheries has been identified in the record. So those risks are out there. The potential risks are out there. BOEM looked at it all and determined at the leasing stage that they didn't preclude putting out a lease in this area because there were potential ways to mitigate those impacts, and because in the end it could be determined that this could be the right place for a wind farm.
But
reserving all the judgment under the statute and under NEPA to do the analysis. Let me just ask you a quick. Maybe I missed this point earlier, but is the next step a site assessment plan?
That has been done, Your Honor.
Is a site assessment plan, why isn't that an irreversible and irretrievable commitment? That's not?
It could be if Mr. Frilla's group had challenged the impacts of the site assessment. The site assessment was essentially, setting up a weather buoy and some limited equipment, and there was never any challenge as to the, so sure, the impacts of putting out that equipment to do site assessment have happened. Those were done, but those weren't, that was, and it's the final point, the lease and the regulations treat site assessment the same way as construction and operations. That is, you need the approval, and if at the point a site assessment plan is presented, there's no way of proceeding without having unacceptable consequences. BOEM's reserved that authority as well, but we have gone past that stage.
I take your point. Judge Millett or Judge Edwards, do you have any questions?
No.
Okay, we'll hear from the intervener.
Thank you, Your Honor.
Yeah, Equinor, 3 minutes.
May it please the court, David Super on behalf of Equinor Wind. Judge Edwards, I think you hit the nail on the head when you referred to appellant's argument as effectively being you can't trust the government, because I think that's what they're saying. There's no question that BOEM has the full authority under the lease to reject any activity in the lease interest in terms of constructing a wind farm, and that BOEM will conduct a full and complete NEPA analysis at the construction and operation plan stage. And frankly, there will be zero harmship because all of the stakeholders, including the appellants, will have a full opportunity to participate in that process. So the assumption that the agency will not go through that process, I think, is the exact incorrect assumption. We should assume that BOEM will comply with its NEPA obligations. And I think I'd like to address this notion that Equinor obtaining approval to actually build a wind farm in the lease area is somehow a foregone conclusion because Equinor has invested resources in the lease.
I don't think anyone says foregone conclusion. I can't speak for my colleagues, but as I understood their questions and my comments, no one says foregone conclusion.
I do think that is appellant.
Is it okay? But for our purposes, at least for now, is it at least a reasonably predictable consequence?
You're right.
But it's, I got to assume you wouldn't have done this if it wasn't, reasonably predictable that this could all work. You've got to dot your I's and cross your T's and get all your ducks in a row, which I assume your construction operations plan did.
Your Honor, what I can tell you in utmost sincerity is that my client recognizes the risk involved in this project because BOEM does retain the authority to preclude any construction activities based on.
Now, my question is different. It's not that there's zero risk. It's how high is that risk? How reasonably predictable is it that I assume you submitted a construction and operation plan that, in your view, fully complies with all statutory and regulatory requirements?
We did because of the risk. Actually, Equinor has spent years developing a construction and operation plan for submission to BOEM. And when that plan is subject to review, BOEM, other agencies, the public, really all stakeholders, including the appellants here, can assess the impacts of that construction plan, and BOEM can decide based on the OXLA factors and based on a full NEPA analysis whether it's going to let that plan go forward or not. Yes, Equinor has confidence in the plan, of course. It invested money in it, but that is not to say that it does not recognize the substantial risks that this project may not go forward. And I think it's important to keep in mind that all of the commitments, financial commitments that have been made toward this project do not include BOEM. I mean, BOEM has retained under the lease and under its regulations full authority to review the construction and operation plan, assess it under NEPA, assess it under the OXLA factors, and decide whether that plan should be allowed to go forward. So these commitments are commercial commitments, made by Equinor, made by the state of New York, but they all recognize that it's up to BOEM to decide whether this project can go forward. And those commitments have not been made by BOEM. I think the place to look for the commitments made by BOEM is the plain language of the lease. And I agree with the court that Peterson really is on all fours with this case, and it is controlling here. I see my time is up. I want to just mention
it's an odd lease because it has that language, but it also has a 25-year operating term.
Well,
what's up with that?
Well, what's up with that, Your Honor, is if the plan is never approved by BOEM, then that operating term, that term will be rendered fairly meaningless. I mean, Equinor right now has
it seems a lot for this lease to. It has a preliminary term, a site assessment term, and then an operations term, and it goes in great detail about operations and payments and
certainly
more mathematical formula than I can understand.
Certainly,
that seems an awful lot of work to put into a lease that isn't making any decision.
Well, it's making a decision to grant to Equinor a right of first proposal. Equinor has the exclusive right to do site characterization, which it did, to submit a site assessment plan, to submit a construction and operation plan. The lease provides for a term if that plan is approved, but crucially, the lease reserves to BOEM the full authority to prevent any construction in the lease area. And if I may, on the OXLA ripeness point, I think it's really important to recognize, in answer to your question, Judge Millett, that appellants are still fishing in the lease area. The only immediate effect they alleged due to the lease auction was being precluded from entering the lease area and fishing there. And of course that hasn't happened because at this point, with no construction and operation plan approved, Equinor has no right to exclude fisheries from entering the lease area. They just don't. So there has been no immediate effect whatsoever as a result of the lease auction. So Judge Tuckin was absolutely correct in her analysis on the OXLA.
Yeah. All right. Are there any other questions? Because we're well over time here. Okay. Thank you.
Thank you.
Mr. Frill, you were out of time, but you can take 2 minutes.
Thank you. Thank you, Judge Tatel.
2 minutes. Right.
Yes. The first point I'd note is that OXLA is not controlled by Peterson. The Massachusetts v. Andrus case looked at OXLA considerations at a point of considering offshore gas drilling under a similar provision. So I believe those two claims don't rise or fall together. OXLA, a property right is granted at the time a lease is issued. That property.
Yeah, but you have a different problem. You have another problem with your OXLA, which is the timing.
The timing. There's. We made the decision to file within 60 days because at the point of the lease sale, that's when rights started to accrue.
Do you have anything you want to say? Do you have anything more you want to say about Peterson or the ripeness issues? For
a couple of points. The first is that the BOEM has only looked within the footprint of the lease. Any analysis conducted since the unsolicited bid was was accepted back in 2011 has looked within the footprint of the lease. The second point is expectations and reality matter. The court decided Peterson, but the court also, you're an appellate court and you have the right to look at Peterson and consider it under the facts and circumstances of these cases. And in terms of impacts and expectations and reality matter. New York State has contracted to buy power out of this area already. So there's a hardship. It's not a fair consideration.
Okay, all right. Anything else, Judge Edwards?
No, thank you.
Okay, thank you. The case is submitted.
Thank you, Your Honors.
Thank you.
Honorable Court is now adjourned until Tuesday, March 9th at 9:30 a.m.